Today we are doing Friday. We love Friday. Why do we love Friday? That's exactly right. We get to do civil procedure. There's literally no other reason I can think of to love a Friday. So today we are doing the Erie Doctrine, and as many of you know, this is my first time that I've taught civil procedure too. And so the first time in a long time that I've had to think about the Erie Doctrine, all this other stuff that we've been going through, discovery, and what else do we do? Complaints and motion practice and everything else. It's kind of what you do day to day as a litigator, but the stuff, as it turns out that they test you on the bar exam, not so much. So I would go down the hall and I talked to Professor Cross here, who literally wrote the book on civil procedure. Wrote the book. And I asked him, what's your approach to teaching Erie? He's like, well, you want me to just come teach it? And I was like, yes, I do. So Professor Cross is a wonderful shining example of humanity for that reason alone. He's also going to convince you why you should take his advanced civil procedure class. I don't know, what else do you teach?
That's pretty much it in the procedure class.
Yeah.
And I teach mostly IP stuff.
But teach some fun international law stuff too. Yeah, or anyway. Take
Antitrust, great class in the spring.
I wish I could. Yeah, if you want to go to work for Lyft or Uber or something like that, you're going to be litigating lots of antitrust type things. That's like a hot thing for general counsels, right? Anyway, so he is going to tell you all about Erie, and please give him your full and undivided attention.
All right, so those of you who've had me for class know I don't do PowerPoint in the classroom. I'm making an exception today because we got a lot to cover in a very short time. When Dan talked to me about Erie Doctrine, I mean, the reason I volunteered is really not a topic that ought to be taught in a basic procedure course. It's actually something that in the old days, when I went to school, we had a course called Federal Jurisdiction, and it was taught there, along with all these other weird doctrines like abstention and the Tidewater problem and the 11th Amendment. But we don't have time to offer that upper level course anymore, and so we kind of pushed Erie into the basic procedure class. But it's not something really that a first year procedure professor really ought to know. So what I'm going to do, I'm going to try to do the impossible, cover this doctrine, at least what you need to know for the bar exam in 75 minutes. Stop me if you have questions. I'm a horrible lecturer because I talk really fast, and as if I keep talking, I just talk faster and faster and faster. So stop me if you have questions, or if you want to take a nap, that's perfectly fine too. Okay, so obviously there's a Erie Doctrine named after a case from 1938, before even I was born, but of course there's something that predates that, and so to sort of set the stage, consider what the federal courts did. Federal courts have existed in the U.S. since the nation was founded. The very first Judiciary Act created a system of federal courts. And tucked towards the end of that first Judiciary Act was this kind of weird little provision that said federal courts, unless there's a federal statute to the contrary, a federal court shall use state law as the rule of decision in the case. All right, so that's called the Rules of Decision Act. The statute actually still is there. You can find it at 28 U.S. Code, Judicial Code, section 1652. Wording's been changed a bit. The relevance of that change we would talk about in a more in-depth discussion, but you don't need to worry about that. Just realize the statute's there, and as a general matter, requires federal courts to use state law as the rule of decision. So what did the federal courts do? Well, if you had a state statute is clearly state law. And so federal courts obediently would apply state statutes in cases heard in federal court. Now, typically these are diversity cases, because if there's a federal question, you're obviously going to apply the federal law. But if it's a diversity case, a state statute governs. Federal courts, since 1789, have been willing to follow state statutes. There's also a branch of common law which is called local rules. And the best example are rules that pertain to land or the allocation of water. And so as you might imagine, the common law rules governing taking water from a stream are very, very different in the wet Northeast than they are in the dry Southwest. There's in fact fundamentally different water law systems. Those are local rules of common law, and in fact federal courts would follow those. But pretty much everything else the federal court said, well, we're a court, we're kind of like that state court across the street. And so what are we going to do on a general question of tort law or a general question of contract law? Well, what we're going to do is what a state court would do. If when Kentucky is faced with a new common law question, do we adopt negligent infliction of emotional distress? The Kentucky court says, well, I don't know, what do we think the best view is? Let's look at what the other courts do. We don't have to follow that, but let's just sort of figure out what the best rule is on that subject. And that's what the federal courts did from 1789 until 1938. On a question of tort law, a question of commercial law, a question of mercantile law, which is an old-fashioned distinction you don't need to worry about, federal courts basically figured out what they thought the best rule is. And if you think about how precedent works, well, what precedent is a federal court going to follow? They're more likely to follow their own court of appeals than they are the state court across the street, because the state court across the street cannot overrule them. And so you had this sort of 51st is inaccurate because we didn't have 50 states then, but you had this extra body of judge-made law. You had the common law as it existed in Kentucky and Indiana and North Carolina and Maine. You also then had the common law as it existed in the federal courts. And we called that, no surprise, federal common law. But it's a very, very tricky phrase. Again, don't worry about the details, just realize that prior to Erie, federal courts made their own tort law, made their own contract law, unless a state statute provided otherwise. And at times that federal rule was entirely different than the rule in any state. So you might have a party subject to a different rule by virtue of the fact that that party went to court in federal court based typically again on diversity. So all that changes in 1938. The Erie Doctrine is named after a case, no surprise there. It's not E-E-R-I-E, by the way. That's like a real common misspelling on civil procedure exams. There's only two E's in the name. Erie Railroad versus Tompkins, personal injury case along a railroad. I won't bore you with the legal issue. But the federal court did what the lower federal courts did, what lower federal courts did. They said, well, we don't care. The accident happened in Pennsylvania. And the federal court says, we don't care what Pennsylvania's rule is on this subject, etc. We don't care what Pennsylvania's rule is on this subject. We're going to follow what we think's the better rule. And the rule was a rule of negligence. Erie says you can't do that. What federal courts must do in these cases, and it cites as authority for that proposition the Rules of Decision Act. What federal courts must do is, in fact, follow state law. You, the federal court, because every state would have applied Pennsylvania law to govern this case, you, the federal court, must also apply the Pennsylvania rule on this subject. You can't apply some federal rule. You've got to defer to Pennsylvania law. Now, the reasoning, it could just be simply a reinterpretation of this Rules of Decision. But what makes Erie sort of a case for all time is that the court goes far further. They said, well, yeah, federal courts have been doing this for about 100 years. And if it was only a matter of interpreting the statute, we wouldn't overturn it. But actually, it's constitutional. And so Erie thinks, at least, the court in Erie, thinks that the question is one dictated, or the rule of the case, is one dictated by the Constitution. Now, we spend about an entire class in advanced procedure trying to figure out what the constitutional basis for Erie is. Court cites equal protection, it can't be that. But basically, the argument is one of separation of powers and federalism, sort of a mixed argument. And so the argument goes something like this. Well, the first premise is, what is common law? Common law rules are not an interpretation of some Platonic form out there. But the old view of the common law was it was out there, and it was the judge's view to figure out what it was. And the court says that's not the case. Legal realism running rampant at the time. The court says a common law rule is really law making, just like a statute. A judge-made rule is a rule made by the court. It's not an interpretation of something in the ether. So you've got federal courts, when they're making federal common law, are making law. All right, what's wrong with that? State courts can make law under this new model. Why can't federal courts? Well, the problem is that in the federal system, Congress makes law. But Congress can't make every law. You might be taking Constitutional Law 1 now, at least in theory, the way the Constitution's written is Congress can only make certain categories of law. They can't make any law they want. They have to fit within the Commerce Power or the Intellectual Property Clause, the Military Clause, the Post Office Clause. Congress is a legislative body of limited authority. All right, so far so good. But when we turn to the federal courts making law, would you have those same limitations? No, because a federal court could, in theory, pass a law to govern any diversity case. A purely intrastate tort case could be a diversity case if the parties were from different states, even though the transaction occurred in a single state. Nevertheless, a federal court would have the authority to make a rule governing that case. And so that would give the federal courts this sort of wide open authority to pass laws in areas that Congress could not regulate. It didn't matter that in Erie itself, Congress could have passed that law. What matters is Congress hadn't passed that law, and you have a court with really unfettered authority making that law. And so the court says in Erie that the unconstitutionality of what courts were doing before leaves us no choice but to overturn and to establish this new rule that federal courts are limited in their lawmaking authority. Yes?
So basically, Erie kind of closed what some might see as a loophole for like getting around the fact that Congress only has so much lawmaking power.
You could think of it as a loophole. You could think of it as sort of a lack of boundaries, either way. But yeah, it's a loophole in the sense that the federal courts can reach into areas denied to Congress. Correct. All right. Very good to stop me because then I'll slow down a bit for the next couple of minutes. Okay. So, with that said, that's Erie itself. So, the doctrine doesn't stop there. It continues to develop, and there's only 3 cases you need to know in the Erie doctrine: Erie, guaranteed trust, and a case we'll talk about in a second called Abbott. You don't have to cite them by name as long as you know the rules. So Erie is 1938. 7 years later, the issue comes back to the Supreme Court in a case called Guaranteed Trust versus York. And Guaranteed Trust versus York basically says, just kidding. We didn't mean to say that federal courts have no authority to make law. Federal courts do have some authority to make law. More particularly, federal courts have the authority to make laws to govern their own procedure. And so a federal court can create a rule of law that dictates what goes on in federal litigation, even though that law may differ from the rule that applies in state court. All right? So now we've just carved a huge exception into Erie. Federal courts have the power to make rules of procedure. The problem is, and the problem that haunted the court from Guaranteed Trust for the next 20 years, is that how do you define procedure? And so the issue in Guaranteed Trust, I'll simplify it a bit, The interest in guaranteed trust is you have a state statute of limitations which had expired. All right, the state says you must bring this claim within, I think it was 1 year, maybe 2, doesn't matter. State law says you have to bring the case in a certain amount of time or the claim is lost. That time period had expired. And the federal court, the lower federal courts, didn't want to follow the state limitations. Why they didn't want to do so, I won't bore you with, but they say we're not bound to follow that. Well, if you think about a statute of limitations and how you would label it, most of us approaching the issue ab initio would label it procedural. It doesn't have to do with your right to win or lose. It's simply how long do you have to bring the claim. That looks pretty procedural. And in fact, if you look at other areas of the law, choice of law, for example, statutes of limitation are clearly procedural. If you look at retroactivity law, statutes of limitation are clearly procedural. Supreme Court in guaranteed trust says, but for purposes of Erie, statutes of limitation are substantive, which means the federal court must follow the state limitations period, and therefore must dismiss the case because the limitations period had expired. Now, how could the same rule be procedural for some purposes and substantive for purposes of Erie? Because substance and procedure is really just a conclusion we reach. And you have to figure out the policy or the underpinnings of the rule in question to determine the real issue of whether something is substantive or procedural. Erie, unlike choice of law, unlike retroactivity, Erie deals with a federal court's power to even make the rule in the first place. And therefore, how we measure what is procedural works out very differently. Guaranteed trust came up with a test to distinguish substance and procedure, but the courts rejected it. And I'm not going to say it to you because students have this irritating tendency to give me the guaranteed trust test, not the current test. So I'm not going to use the magic phrase from guaranteed trust because it's not the law anymore. Okay, but the important thing about guaranteed trust is, again, it says no, federal courts do have authority to make rules of procedure. So if we dig a little deeper into that concept, we start to recognize, well, actually, the issue's not quite that straightforward. Because a federal court might have the authority to regulate its own procedure in 2 different ways. And I'm going to call those ways inherent and delegate. And so inherent is really what the court's focusing mainly on in guaranteed trust. You are a judge. You've just been appointed a federal judge. Yay, life tenure for you. Mm-hmm. So you can't have your salary reduced while in office, and you get to wear a fancy black robe that the government buys for you. So, Mercedes on clothing please. None of that's important. What's important is you are a judge. By virtue of the fact that you're a judge, you can do certain things. If someone stands up in your courtroom and starts singing the theme song from a hit musical, you can tell them to sit down and shut up. If they don't sit down and shut up, you can sanction them. You have the authority merely by virtue of the fact that you're a judge to do certain things that are lawmaking. Sanctioning an attorney or a client is lawmaking. And therefore, by virtue of the fact that you are a judge, that alone gives you a limited power to control what goes on in the process of litigation. You can't write tort law. You can't discard the Uniform Commercial Code in contracts, but you can control the way those issues are litigated in your court. But you might also have a second source of authority. Because if you think about the federal system, well, there's one entity in the federal system that clearly has the power to make law. And it's not the presidency, notwithstanding the current administration's claims, it's Congress that has the power to make law. And so if Congress can make law that deals with federal procedure, that's not an obvious proposition, just take my word for it. Congress can pass laws that govern the procedure in the federal courts. And Congress can pass other laws that have nothing to do with procedure. Congress can pass tax laws or bankruptcy laws or laws that regulate interstate commerce. And a second, admittedly non-obvious proposition, if Congress has the power to make laws, it can delegate that power, at least to some extent, to the federal courts. More particularly, Congress can delegate its power to regulate the procedure in federal courts to the federal courts. Well, big whoop, Congress could do so. Is there any evidence that Congress has done so? Well, yes, there is. You may, I'm sure it's kept you awake at nights wondering, where did the federal rules come from? Were they found on 2 tablets on Mount Sinai back in the old days? No. The federal rules of civil procedure were not passed by Congress. They were enacted by the Supreme Court. They were enacted by the Supreme Court under a delegation of authority from Congress. And that delegation of authority has a name, the Rules Enabling Act. And it's also found in your handy judicial code at Section 2072. Section 2072 gives the Supreme Court the power to enact the federal rules of civil procedure and other sets of federal rules. I'll mention a couple of those later, but really our main concern here is the federal rules of civil procedure. So really 2 fonts of authority for a federal court to enact federal law. The inherent, every federal court has that power. Delegation under the Rules Enabling Act, only the Supreme Court has that power, although purely as a footnote, I can't imagine you would ever encounter a question. There's also another statute, 2071, that gives the district courts the power to pass local rules. So if you realize it's there, that's where the local rules come from. But it's not likely to come up in an eerie question. So 20 years of confusion, maybe that's an understatement. The courts keep trying to figure out a workable test for substance versus procedure. They keep trying to fit it within the way Guaranteed Trust looked at it. Utter abject failure. So finally, 20 years after Guaranteed Trust, the Supreme Court decides another case. And this other case is Hanna versus Plummer, although it's from 1965, which is after I was born. But even though it's from 1965, you're shocked by that. Even though it's 1965, it really remains the rule today. There's been some tweaking, but the fundamental approach of Hanna remains the rule that how we gauge an eerie question today. So, having said that, what is the rule or the test of Hanna? Not just one, there's 2 tests. Because the real gist of Hanna versus Plummer is that the court finally realized this inherent delegated distinction we just made. That there are 2 fonts of authority for a federal court to make law, but we're not going to measure them the same way. Yeah, they both sort of generally speak in terms of substance versus procedure. The inherent power is the power to regulate procedure in my courtroom. The delegated power is the power to enact rules of practice, procedure, and evidence. But that doesn't mean the same thing. And it doesn't mean the same thing because it's really measuring the authority of different branches. The inherent side is measuring what is a court's power to regulate its procedure. And that's a limited power. The delegated is a far broader power, given that Congress has a largely unchecked power to regulate procedure in courts, and in fact can tap into its other powers. When you're looking at a rule pursuant to the delegated power, again, typically a federal rule of civil procedure, you're going to measure that by a very, very different test. Because at its core, what you're measuring is could Congress have passed that law? And that's a different question than under the inherent, where you're asking, can the court pass the law? Now, we don't stop there under the delegated. We ask A, or one on my slide, one, could Congress have passed the law? Two, are there any limits on the delegation from Congress to the court? And if the answer to that is yes, you also have to fit within the additional limits Congress placed on the delegation. All right, so that's the framework of hand. And having said that, let's now dive into the two tests that the courts use to measure the validity either of a federal rule of procedure or of some inherent judge-made rule. I'm going to start, although it kind of takes Hannah backwards, I'm going to start with the delegated rules. So the delegated rules, again, the Rules Enabling Act is the main source of delegation. It's not the only source. There are other sources of delegation, but again, I can't imagine you'd ever have a test question, unless Professor Cannon's incredibly cruel, that involves some other delegation of authority. So let's focus on the Rules Enabling Act. Yes?
Can you send us this PowerPoint, please?
I can if you send me an email.
Yeah, thank you.
Okay, if you want to send me an email, I can send you the PowerPoint. So that doesn't mean you should all go to sleep now, because what I say in addition to the PowerPoint may be of help or it may not. So, what rules were made under the Rules Enabling Act? Again, the rules of civil procedure, the rules of appellate procedure, bankruptcy, the admiralty rules, a whole bunch of them. And again, most questions tend to focus on the federal rules. So civil procedure, although there is one important Supreme Court case that deals with a federal rule of appellate procedure. Analysis works the same way. So in order to figure out the test for a rule of civil procedure, where would you look? Well, it might help to look at the Rules Enabling Act itself. And if you do so, lo and behold, you will find there is language in the statute that tells us how to measure the validity of a rule of civil procedure. Because if you parse the Rules Enabling Act, you'll find it gives the courts the power to create rules of practice, procedure, and evidence. Total footnote, you don't need to know this. The rules of evidence were actually not done pursuant to the Rules Enabling Act. They were done by Congress because of this kind of strange debate that was going on. But all the other rules are under the Rules Enabling Act. So the first issue is it a rule of practice, procedure, or evidence? And I'll flesh this out here on the next slide. What you're measuring on that first part of the test is really, does this fit within Congress's power to regulate procedure in the federal courts? Congress did not delegate to the Supreme Court its power to regulate interstate commerce or its power to pass patent and copyright laws. It delegated only that portion of its power that allows it to regulate procedure in the federal courts. So the first part of the test asks, would it fit within Congress's power to regulate federal procedure? But then Congress didn't stop there. They put additional limits on the court. One limit, which isn't on the slide, is that actually when the Supreme Court enacts a rule, it doesn't automatically become effective. Congress has until the following, I think it's December 1st, to reject the rule. If Congress doesn't say anything about it, the rule becomes effective. But Congress really has a veto power, and they've exercised it a couple of times. But the more important limitation for our purposes is, even if it is a rule of practice, procedure, or evidence, it cannot abridge, enlarge, or modify a substantive right. If it does so, then the federal rule of civil procedure is invalid, does not apply, and you would have to apply state law on the subject. All right, so again, that's an additional limitation. That's not one that binds Congress. Congress didn't want to give an unchecked authority to the courts. So how do we apply that Rules Enabling Act evidence or analysis? To me, 90% of the battle is the first question. Is the rule a rule of practice, procedure, or evidence? Now, What do we mean by that? I think that the best way to analyze that is, are you kidding us? Is this really an attempt to regulate a substantive right couched in terms of procedure? And so one purely made up example I often use is, Rule 54 governs judgments. Suppose the court were to amend Rule 54 to say, well, in an attorney malpractice case, the court may not issue, no court may issue a judgment in excess of $10,000. Does that look on its face like a procedural rule? Sure. It deals with the court's issuance of a judgment. But that's a scam. That's the courts really regulated attorney malpractice law. That's really a substantive rule couched in terms of procedure. Now, if you've ever studied, and I'm sure most of you have, if you've ever studied constitutional law in the British Commonwealth system, there's actually a wonderful concept they use that really fits well here. It's called pith and substance. In order, you're asking, is the law in pith and substance really what it pretends to be? And if it's not, then it falls outside that power. We don't really use that in the US, and it's unfortunate, at least here, because it's a great way to think about this. Is it really an attempt to regulate procedure, or are you trying to use procedural terminology to disguise a substantive law? So that's part one. Once you clear that hurdle, once the federal rule clears that hurdle, once we determine it is, in truth, a regulation of practice, procedure, or evidence, the second part really doesn't add a whole lot in most cases. It really adds something only when when the rule entirely guts or an existing substantive right, or creates a brand new substantive right. And so I don't know why I thought of this. If you had a rule of procedure that said an attorney must write her own pleadings, she cannot copy the pleadings from another attorney, well, that would really be a copyright law. That would create a brand new substantive right, even though it's a right that would only apply in the context of litigation. But other than that, the fact that the rule may change the ultimate outcome of the state law claim doesn't mean that it abridges, enlarges, or modifies. Don't take those terms literally, because most procedural rules can have an effect on the substantive right. What's more important is, can you get to the same end place by following the federal rules in the federal court and the state rules in the state court? As long as that's true, then you're really not abridging, enlarging, or modifying the underlying rules. Okay, so that's the test we use for rules made pursuant to the Rules Enabling Act. Again, what we're talking about here is mostly the federal rules of civil procedure. Test two. What happens in the case of an inherent rule? A federal rule made by a federal judge, either the Supreme Court or a district court judge, where there's no federal rule of procedure on point. Here, remember that now we're talking about not Congress's power to make law, but the court's inherent power. And that is way more limited. Because of Erie, because of the early cases, that test is far more circumscribed. And the court really in Hanna came up with what I think is actually a wonderfully workable test. And those who've had me for class know I don't often say that about Supreme Court tests, but this one actually works pretty well, and I think it's a lot easier than the test for the delegated rules. It's really a three-part test. So part one of the test, the test is called the likely to cause forum shopping test. And that's the way the courts refer to it. I'm going to warn you against that simplified name. You can call it the likely to cause forum shopping test, but calling it that misses a couple of nuances. So I'm going to phrase it as a three-part test. The difference between state law and what the federal court wants to do must be likely to cause forum shopping. Forum shopping means choosing between federal and state courts. So it has to be likely to cause, if it's likely to cause forum shopping, for a different outcome based on a difference in governing law, then the federal rule would be substantive, not procedural, and you'd have to follow state law. If, by contrast, the difference between federal and state law would not lead to forum shopping, or it would not lead to improper forum shopping, then the federal court can apply its rule even though it's different than the state law. So let's do a couple of examples. First, I'm sorry, go ahead.
I was curious what the difference in proper.
I can't hear what you're saying because there's a big blaring fan here.
My bad. I was curious about the
No
difference
fans, man.
between proper and improper forum shopping.
Well, I'll cover that in a second.
Sweet.
Okay, so take first the statute of limitations, the question at issue in guaranteed trust. If you go to state court, you're going to get kicked out because the statute of limitations has run. Federal court wants to apply a different rule, which would allow your case to proceed. Which court would you prefer? Duh, federal court. If you go to state court, you're kicked out on your can. If you go to federal court, you at least have a chance of winning. So that difference in rules would clearly cause forum shopping. We don't need the second and third parts of the test. That rule is substantive. Federal court has to follow state limitations. All right? Example 2, the issue actually in Hannah. In Hannah versus Plummer, you had, it was a suit against the executor of an estate. And under state law, you had to serve the executor in hand in a case against the estate. As you know, in federal court, you don't have to serve in hand. You've got other options. One option is you can leave it at the defendant's abode with someone of suitable age and discretion. And so the party did use the federal, it was a suit in federal court, they used the Rule 4 service method. All right, would that lead to forum shopping? Well, maybe. This is going to start touching on your question. Would that lead to forum shopping? Well, maybe. I mean, probably not. When you're making your choice of whether to go to federal or state court, yeah, the federal service method's easier because you can leave it with somebody else other than the defendant herself. That may or may not cause forum shopping. Even if it would cause forum shopping, it's not bad forum shopping because you're not forum shopping for a different outcome. You're just forum shopping to make your life easier. Final example, which I think more clearly illustrates your question, a difference in filing fees. Let's suppose that the filing fee in federal court's $100 in your district, but state has a special filing fee for this sort of case of $25,000. Would you engage in forum shopping? If you're a plaintiff, absolutely. You don't want to spend $25,000 when you get the federal court for $100. Does that mean that the federal court has to follow the state filing fee rule? No. Why not? It would lead to forum shopping, but it's not forum shopping for a different outcome. And again, if you think along the lines, if I go to federal court and play by federal rules, versus if I go to state court and play by state rules, will I reach ultimately the same place? And the answer is yes. Yeah, you're $24,900 poorer if you go to federal court, but we don't care about that. We care about the ultimate judgment that you receive. As long as that's likely to be the same, then that's not the sort of forum shopping we care about. So that's the test. I actually, again, think that's a very workable test. Again, I personally have much more difficulty with the rules of practice, procedure, and evidence part than I do with the likely to cause forum shopping test. So with those two tests laid out, there are, as you might imagine, special cases. I'm going to deal with the main 3 situations that are special. There's a couple of others. First, equitable remedies. This doesn't come up a lot, but it comes up actually a whole lot more often than you might think. So what's the rule here? Well, if you think about forum shopping for a different outcome, we naturally think of the remedy the court gives you as the outcome. But there is a special rule that deals with equitable remedies. We talked about equitable versus legal remedies at all?
Not in those terms.
Well,
Talk a lot about
and because that's more likely done in the remedies course, upper level. So you may have done so actually in torts and contracts. Damages is the quintessential legal remedy, but there's other specific remedies available. The injunction's the classic remedy that's equitable. Specific performance of a contract is an equitable remedy, and there's a whole bunch of others. What guarantee trust actually says, and this sort of side passage is, well, as long as the question of who wins or loses is the same in federal and state court. As long as you would win in state court, then the federal court can grant you whatever equitable remedy it wants, not damages, but whatever equitable remedy it wants, even if state law would not allow that remedy. And the simplest example is many states will not grant a mandatory injunction requiring an employee to continue working. There's hints of slavery in that, even though the employees get paid. Courts will typically, many states will not grant a mandatory injunction in such a case. Even if your state clearly would not, the federal court could if it wanted to. It's not bound by the state's rules governing what remedies are available. Who wins and loses you can't change. But what equitable remedies are available, federal courts have independent authority to do that. And I can explain why that's so if you're really a geek in this area. All right, special issue number 2. Whenever the issue is who decides, which court, judge versus jury, federal courts pretty much think they have the authority to ignore state law. And so even if state law would assign decision of an issue to a judge, federal courts can try the issue to a jury. Now, there are situations where a federal court is constitutionally required to use a jury, the 7th Amendment. We're talking about cases that don't fall under the 7th Amendment, where the constitutional command doesn't require the federal court to do so. But there's nevertheless a federal preference for trying issues to juries. And so if the state court would not use a jury, but the federal court would, the federal court can use a jury. Another more recent case, state law allowed a court of appeals to overturn a jury verdict based on certain grounds. The federal custom would have been to have the trial judge overturn the jury. Notwithstanding the clear command of state law, the Supreme Court says, no, the federal courts can have this standard applied by the trial judge. And so if it's a question of who decides, federal courts don't have to follow states. And then finally, federal statutes. Remember, federal statutes aren't under the Rules of Decision Act anyway. And so if the federal law that the federal court wants to apply is in a statute, long and short of it, you apply the federal law. As long as the law is not unconstitutional, federal statutes are applied in federal law. All right, so those are the tricky cases. So, next let's talk about, should you get an Erie question, heaven forbid, either in this course, on the bar exam, what in the world do you do? Where do you begin? Because I do find that Erie question, at least one particular type of Erie question, which I'll point out, is one of the most commonly missed questions on an exam. It is really easy to disguise an Erie question. I can disguise an Erie question in a question on pretty much any question or any topic you cover in procedure. And because it's easy to disguise them, students often miss them. One way to tackle it, or one way to spot it, my next slide, which I didn't put on here, look how many points are allocated to the question. If this is 1/3 of the exam, and you think it's a question of whether service was proper under Rule 4, you're probably missing something. There's probably something else there, and it may be an Erie question. So, how do you spot an Erie question? First, you have a case in federal court, and for some reason, the question's talking about state law. So that should send alarm bells off. Why is he telling me, he or she telling me about state law? I'm in federal court. What do I care about state law? And so that at least is a signal that there may be an Erie issue here. If it's a clash between a rule of civil procedure and a state law, don't expect the problem to give you the federal rule of procedure. If it's one you studied, we'd expect you to know it. If it's a question of pleading claims for special damages under, is it 9B, whatever, 9G. If it's special damages under 9G, well, and you studied that, well, you'd be expected to know that Rule 9G requires special damages to be pled specifically. So you have to know the federal law, and then the state law, of course, would be given to you. So that's how you spot the question. Once you've spotted it, what do you do? But I think the best way to do it is to kind of approach the issue backwards. All right, I've got this state law. Why might the federal court not apply state law? Well, first, there's a contrary federal statute. Or, second, there's a contrary rule of procedure or other rules enabling act either given to you or one that you should know because you studied. Or there's no federal positive law at all, neither a statute nor a written down rule of procedure. There's either the federal judge just doesn't want to follow the state law, or you've got some federal precedent that suggests that federal courts do something to the contrary. And I always love to use the example of the color of robes. So federal judges wear black robes. But suppose that some crazed UK fan says, well, Kentucky judges have to wear Kentucky blue robes. Is there a federal statute or rule dictating the color of robes? No. Supreme Court probably has some goofy rule, but other than the Supreme Court doesn't tell federal judges what color of robes they have to wear, nor do I think they would tell them they have to wear robes. So would a federal court have to follow that? Well, if for a federal judge not to wear a blue robe in this particular state would be a federal judge ignoring state law. And so that would raise the third category of Erie problem. Can a federal judge, pursuant to her inherent power, just ignore state law? All right, so you've identified the problem, or you've categorized it in one of those three categories. What you do next will differ fundamentally depending on the category. If it's a federal statute, you stand up and cheer. Probably not a wise idea in an exam situation, but you mentally cheer because it's super easy. If it's a federal statute, all you have to determine is, does it really apply here? If it really applies, you apply it. End of story. Now, statutes in the real world may be unconstitutional, but it's rare that, certainly in a procedure class, you would not have a question as to whether a federal law violated free speech. And so you can pretty much assume the federal statute's valid. If it's valid, if it really applies, you apply it. If it's a federal rule of civil procedure or other rules enabling act rule, you apply the analysis we did a little while ago. That two-part rules enabling act test. First, is it a rule of practice, procedure, or evidence? Second, does it abridge, enlarge, or modify a substantive right with the vast weight of that analysis in the first part of the test? Hint, if it's an existing rule of procedure, one that's in your rule book, err on the side of the rule being valid. The Supreme Court has never found one of the federal rules invalid, and if you think in practical terms that makes perfect sense, who decides, or who enacts the rule in the first place? The Supreme Court. Who decides whether it's valid? Supreme Court. So they don't often admit their own mistakes, although they admit. So, if it's an existing rule of procedure, err on the side of being valid. Feel free to come up with a creative argument as to why the rule is invalid. There are actually a number of them that you could make a colorful argument that they're really more a regulation of substantive rights. But again, if you're at all in doubt, err on the side of the rule being valid. Again, although the Supreme Court has not yet found a rule to be invalid, they've only construed perhaps a dozen under this analysis. So there's a whole lot of other rules that have not been analyzed. On the other hand, you may encounter a made-up rule, where the professor or bar examiner makes up a new rule. Well, that's a signal to have fun. Because if they make up a new rule, then you can be much more creative and is to argue why this is really a surreptitious attempt to regulate underlying substantive rights, especially if it is a rule that's confined to a particular type of claim. A rule, for example, that applies only in products liability claims. If you get one of those, then I think you should feel free to be creative and is to argue why, in fact, the rule is invalid. Such a rule would have to be given to you because it doesn't actually exist. You can't be expected to know what goes on in the strange crevices of a professor's mind. Okay, so that's category 2. Category 3, no positive federal law. The judge just wants to apply a contrary rule. First, look to see if it's one of those special situations. Is it an equitable remedy? Is it a judge, jury, or level of court that decides question? If it's not one of those, apply the likely to cause forum shopping analysis. And here I'll repeat a caveat that I mentioned a while ago. This is the one that people just miss. I don't know if it's because of study aids or the way they do it in the bar review. All of you start thinking of Erie questions as, here's the state law, here's the federal law, and I guess you have to figure out which test to use. That works in categories 1 and 2. That often doesn't work here because you don't have a federal law. Take the black versus blue robe example. Again, there's no positive law or even precedent, to my knowledge, that says federal judges wear black robes. What you're being asked is what's common or what's often called the unguided Erie choice, not guided by a statute or federal rule of procedure. Do I, the federal court, have to follow the state law? And for some reason, if the question is couched in that manner, if you're given state law, and the question is, must the federal court follow it? A lot of students just say, yeah, because there's no federal law here. But again, a decision not to apply federal law is a decision to apply, a decision not to apply state law is a decision to apply a federal law that happens to be the opposite of the state law. So just beware of that. If they give you state law, the question is, do I have to follow it? You use this likely to cause forum shopping analysis. A couple of other points. Likely to cause forum shopping, it doesn't matter whether the party would prefer federal or state law. It might be that the federal rule is more favorable. It might be the state rule is more favorable. It doesn't matter whether the party would prefer one over the other, as long as they would have a preference. That's what matters. Second, it doesn't matter whether this plaintiff, or in a removal case, this defendant, actually shopped. In many of the cases, the plaintiff will have picked the less favorable court. That doesn't matter. What you're asking is, would a typical plaintiff, understanding these rules, likely make a choice of forum based on the difference in rules because of the anticipation of a different outcome? So what the actual parties did in the case doesn't concern me. It's only whether a typical party. All right, so let me talk about one more topic. This is something I very much doubt you will ever encounter either in the basic procedure class or on the bar exam. I don't think the bar examiners have ever tested on this, but you need to know it, especially if you are involved in certain areas of practice or administrative law. So what we've talked about is about half of you, and that's the federal court's power to make procedural laws. Well, do the federal courts have the power to make substantive laws? Perhaps the most misquoted phrase in all of the Erie doctrine is a passage in Erie itself, which is often misquoted as, federal courts have no authority to make rules of common law, no authority to make federal common law. What the Supreme Court actually said is, federal courts have no authority to make general federal common law, which the use of that extra term suggests, well, wait a minute, in certain areas, perhaps federal courts do have the power to make common law. One of those is procedural rules. We've talked about that. But even on certain substantive questions, federal courts can make substantive rules. And in fact, we need look no further than the volume that contains Erie to find an example of that. Erie's in volume 304 of the Supreme Court reports. The very next case in that reporter is a case by the Supreme Court called Hinderleader, in which the court applies a rule that it absolutely explicitly labels federal common law to determine how water in an interstate stream is to be allocated. A purely substantive question. Does Colorado or Arizona have better rights to this water? So clearly substantive law, clearly the federal court doesn't defer to state law. So there are areas in which federal courts can even make substantive law. Again, you won't get tested on this on the bar, at least I hope not. Substantive federal common law, the analysis is different. It's really the why that's more important, and we don't have either the time or the interest to do that. So let me just give you some areas where you might think in terms of federal common law. So really think in terms of subject areas. Hinderleader involved the last of those four examples. A dispute between states involving the boundary between the state or allocation of interstate water. When Indiana and Kentucky had a free-for-all as to where the boundary is, we're the only state that actually gets most of, most states end in the mid-river. In Kentucky and Indiana, we actually own to the high water mark on the Indiana shore. Yay us, boo Indiana. So
For now.
For now, you guys know
I'll
that.
take it back.
Yeah, you could actually have it back. It's kind of dirty. So the Supreme Court just determines that rule. And if that makes some sense, because it would make no sense to apply Kentucky or Indiana law to that, you need to know where the land is to know which law would govern anyway. So you've got a sort of a dog chasing its own tail. So interstate dispute involving boundaries, rights and obligations of the U.S. itself. When you get your tax refund check and you sign it to a holder in due course, is the U.S. subject to that? That's an obligation of the U.S. That would be a question typically governed by federal common law. Military cases, even outside military statutory law, there's a lot of federal common law that involves the military. One I didn't put on here, federal public lands, although there's a court there. And then finally, international relations. The law governing a famous case when Cuba nationalized the sugar industry and when you had the revolution. To what extent was the U.S. act of state doctrine going to immunize the Cuban government for what it did? We aren't going to look to any state law on that. We're going to look to federal law. Again, just understand that federal common law is likely to apply in those cases. None of the stuff we talked about earlier matters. If it's substantive common law, it clearly would involve foreign shopping. We don't care because it's a separate and discrete area. All right, and as Dan mentioned at the outset, if you really love this stuff, and I'm sure you do, in advanced procedure, we spend 2 whole weeks on it. Now, we spent a whole day on Erie itself. So I know that excites you to no end. You can't wait to go at it. We do other things in the class too. But, okay, any questions on any of that? Of course, as soon as we let it out, they're done for the day, right?
That was even less than.
Less than 75
minutes.
minutes. I talk fast. I warned you. That you always oh, did I hit a raw nerve there, folks? I'm sorry.
Well, I just have to see like a sample question to know how to apply.
If you want a sample question, send me an email. I can send you a sample question. And it might be, sometimes they can be tricky. But
I can also take care of that and maybe we'll look at some of those next Wednesday. Talk a little bit more about it, just to kind of.
You know, actually, what are good questions? In the main part of the book, there's like 7 questions, because I think you assigned the electronic version.
Yeah.
But if you look in the paper version of the book, at the end of the chapter, there are 7 questions. Try those, because those kind of have a level of trickery to them. And you know, that might be a good basis for discussion.
Let's go over those in class.
Because he's got the teacher. No, I'm not going to send that teacher manual to you. Anything else? All right.
Which, I have a question.
Yeah.
So I'm thinking about this as a practitioner, and so what are the sort of landmines that you see out there that have yet to be litigated? Is there something that is sort of lurking that a practitioner, if they get out and get into practice, they're likely to run into and have to contend with?
The big issue now is tort reform. Because tort reform, in fact, there was a case I didn't mention, tort reform can often be couched in terms of a procedural rule. And so New York passed a law that said you can't use class actions in mass tort cases. Well, you've got Rule 23 of the federal rules that says you can use class actions, and it doesn't limit it to type of case. And so that's an eerie question. And it's a kind of a weird, eerie question because, in fact, it led to a point that I didn't raise, and you probably don't need to know, but it's kind of conceptually interesting, in that New York's law is clearly intended to be substantive. They're trying to cut back on a party's ability to recover in tort, because if I suffered especially a minor injury, I'm not going to sue by myself, I'm going to sue as a class action. The Supreme Court said Rule 23 governs in federal court. You can use class actions in these cases. We don't care whether the state rule is substantive. We care only if the federal rule is substantive or procedural. So really right now, a lot of the cases have arisen in the context of tort reform. Down the road, I mean, there's always stuff going on in substantive federal common law, but down the road, as far as what sorts of issues will come back to the fore, I'm not sure. But right now, and for the past 15 years, it's really been tort reform in the States.
Anybody else? Are you going to make me let you out 10 minutes early?
On a Friday.
It's painful.
It's not sunny, at least it's getting cloudy.
I suppose I owe it to you. All right, well, thank Professor Cron for
Here you go, sir. Thank you. Go, my car works. I'm gonna run to the dentist, and then try and come over there and be a little